Starting with issues regarding the legal fraternity, because barely 24 hours after petitioning the Criminal Investigations Department to investigate Justice Yonny Kulendi and Richard Jakpa over alleged interference of administration of justice, Daniel Marfo Ofori-Atta, a Chebi indigene, has escalated the matter to the presidency. This time, he is asking President John Mahama to remove Justice Yonny Kulendi as a Supreme Court judge, accusing him of improper interference with a trial involving Dr. Ato Forson and two others. Lord Eduasare reports.
The war of petitions began with businessman Richard Jakpa, who was the second accused in the ambulance trial. Together with Dr. Ato Forson and Sylvester Animana, they were facing charges of causing financial loss to the state. In July, Richard Jakpa petitioned the CID to investigate the former Attorney General Godfrey Yeboah-Dame, accusing the latter of soliciting his cooperation to testify in a manner which would incriminate Dr. Ato Forson, the first accused. He attached WhatsApp conversations between the two of them as evidence to make his case. Few months on, private citizen Daniel Marfo Ofori-Atta also petitioned the CID to investigate Justice Yonny Kulendi and Richard Jakpa over allegations of interfering with administration of justice. The petitioner alleged that Richard Jakpa, with the help of his cousin, Justice Kulendi, sought to obstruct justice by pressuring Godfrey Dame to discontinue the prosecution against the businessman. Ofori-Atta further alleged that, upon failing to do so, Richard Jakpa went on a spree seeking to tarnish the image of the former Attorney General. In a petition dated September 30 addressed to President Mahama, Daniel Marfo Ofori-Atta outlined 4 grounds for removal against Justice Yonny Kulendi, including alleged ethical violations. He attached the cross-examination of Richard Jakpa by the Attorney General in the ambulance trial, WhatsApp conversations between Richard Jakpa and the former AG, the High Court ruling, as well as other court documents to buttress his point. It remains to be seen if the President will act on the petition by Daniel Marfo Ofori-Atta. Lord Eduasare, TV3 News, Accra.
Right, let's get some, legal perspectives on this. Martin Pebu is a private legal practitioner. He's joined us for a quick chat on this. Counsel, good evening. Thank you for your time.
Yes, good evening, Name.
Right, to start with, we're told, clearly looks like Article 146 has come back into mainstream conversation. This time around, it's a Supreme Court judge whom the president has been petitioned to remove. But on the face of it, as a lawyer, what are your initial thoughts and the grounds on which this petition has been sent to the president? It is interference with judicial process. What do you make of it?
Yeah, so the first thing is that the Supreme Court has warned time ad nauseam, endlessly, that the petition should not be published. It's not even should, must not be published. You say, so it's actually a bit, let me say, retrogressive, that despite many Supreme Court decisions, still these petitions keep leaking and being published. You say, because with that, it affects the process. That's how come that the Supreme Court said no, when a petition is made in a J2 versus Attorney General, the Supreme Court said the only thing that should be said is that the petitioner can announce to the media that, yes, I filed the petition. I'm not suggesting that it's the petitioner who leaked this petition, no. But what I mean is that under the law, the Supreme Court says that the petitioner can inform the media, the general public, that he's filed a petition. That's it, but not the content. And so neither the petitioner nor any citizen, right, has a right to publish the petition. So in order for us to mitigate the effect of what has already been done, maybe we would not discuss the merits, so that at least we would see that as for it being published, it's been published already. So it's not our fault. But if we were to go into the merits, then it will be seen as a fresh step that we are now prejudging the matter.
Certainly.
But what I can also say is that the next point I wish to make is that, well, it tells you that citizens are beginning to assert themselves more and more because this matter was in the public domain last year. We beat it many times on the key points and other TV3 programs, and we saw how it showed that the Attorney General was involved in unethical conduct, etc. Right? But now that the petitioner has chosen to take on Justice Yonny Kulendi, it also means that once we're condemning the Attorney General, it's not within our right to just condemn the petitioner. Let him have his day in court. That's before the whether before the Council of State, whether he succeeds beyond that point or not. Let's just simply say that he should have his day in court.
Right, and Council, clearly it's an issue of concern, and like you indicated, the petition was supposed to have gone straight to the President, but the full details of it is already in the media. So it's subject to what many have described as, public court to discuss and talk about it even before the presidency acts on it. But does that have any bearing on at all on the final outcome, if any, when the public speaks about an issue?
No. What the Supreme Court said in the Justice Paul Berry versus Attorney General, Chief Justice Tiger PI, etc., was that they cannot cancel the petition. They cannot throw it out just because it has been leaked. In the same manner in the Justice in the Petition case, that was the same thing. The Supreme Court said they can't throw out the petition just because it's been leaked. So that won't have a bearing. But maybe if the leaker, the person who leaked it, is caught, then perhaps there will be the full extent of the law will be brought to bear on him.
Right. Okay. And finally, they're still on the same strand of conversation having to do with Ato Forson's case. We know that the General Legal Counsel has also been petitioned to take action against former Attorney General Godfred Dame. He has responded to it. We'll bring the response to our viewers in a bit. But before you leave us, what are your general thoughts on his response to the fact that the General Legal Counsel is being asked to look into his conduct, having spoken to Richard Jakpa in the build-up to the case that was in court?
So the same comments as I gave for the Article 146 proceedings. So now, when a lawyer is also facing disciplinary hearings, it's also supposed to be in camera. That's Regulation 15 of the the professional ethical rules, right? The disciplinary rules. So we enjoy the in-camera hearing. So for that reason, we cannot discuss the merits of his response. And so we'll have to wait for the disciplinary committee to come out. So once again, we'll commend the petitioner for taking that bold step. That is what we need citizens to do, to hold duty bearers to account, because we know we're all not happy with the way Godfred Dame conducted himself in that office as Attorney General. He lowered that office to the lowest the extent that we've ever seen in this republic. And so it's good that he'll be facing the disciplinary committee. Yes. Okay. But as to the merits, we'll express no opinion.
We'll hold on for now. Thank you so much, Martin Pebu, for your time. He's a private legal practitioner.